Lordship, item number 27, Lordship have allowed the IA and post the case tomorrow. I am not pressing the IA because the IA is wrongly filed in this case, Lordship.
So what do you want?
The order has been passed, to IA has been allowed. So that I am withdrawing the IA and matter.
IA number कौन सा?
IA number
103 of 24.
IA number 103 of 24
in 7120.
in WPS number 7120 2023. Counsel for the petitioner does not want to press the interlocutory application. The IA is dismissed as not pressed. कल आएगा। उसको रिप्रेजेंटेशन टाइप का ही लग रहा है।
हाँ वही है। फोर्थ DSP।
कल से आप नहीं थे और 1:30 बजे के बाद फोन किया।
Password is from daily list at 10:30. Item 9, WPS 2583 of 2023.
Lords, a case of visually impaired, 100% visually impaired notes that was being rejected, stating that the scheme is in vogue.
ये सर एक ने इंस्ट्रक्शन इनको नौकरी से हटा था, हम तो रख रहे हैं इनको, इनके लिए इनके हिसाब का नौकरी देंगे। और ऐसे भी हम लोग पारा 19 में काइंडली सी द अपडेट यू लॉर्ड से यस यू लॉर्ड 19 that the implementation instruction in 9C, whereas the petitioner falls under the clause 9 for the medical unfitness. There is no whisper in implementation instruction dated itna status quo shall be maintained as the case of the petitioner falls under itna could not process and constitute medical board भी नहीं हुआ, इनसे गुजरे नहीं है अभी, जब होंगे तब फिर इनको नौकरी से कर देंगे। हाँ कोई हाँ कंटिन्यू रहेंगे जब तक इनका है डायरेक्शन दे।
ये फॉल्स जो आप देखिए इसको गलत है ना, फॉल कर रहा है ना, इस which falls under FALLS।
हाँ ये टाइपिंग
AI का एरर है,
टाइपिंग
आर्टिफिशियल इंटेलिजेंस का एरर है। Then he will not be entitled to monetary benefit.
नहीं मॉनेटरी का तो कोई है ही नहीं।
The learned counsel for the parties against this petition has been filed for the following reasons. The learned counsel for the petitioner has submitted that the petitioner has not yet attained the age of superannuation and he is visually and he is completely blind by virtue of certain medical condition which has happened while the petitioner was continuing in service. The learned counsel submits that as per the provisions of clause 9.4.0 of NCWA, the petitioner is entitled for certain benefit, and for that purpose, a medical board is required to be constituted, and the respondent has to take a decision with regard to the medical fitness of the petitioner prior to granting any sanction under NCW. Right? The learned counsel for the respondents has submitted that the petitioner is still in service, and so far as the claim under clause 9.4.0 within bracket of NCWA within bracket medical fitness is concerned, the petitioner is required to be medically examined. The learned counsel submits that for that purpose, medical board is required to be constituted and appropriate order may be passed so that the demands of the petitioner in connection with his benefit under 9.4.0 or one or the other provision of NCWA may be taken to logically. He says that no adverse order as such has been passed against the petitioner as per the contract, as the petitioner has not yet been medically examined. After hearing the learned counsel for the parties and considering the nature of relief laid for by the petitioner in this also finds that even as per the counter affidavit paragraph 19, the petitioner is yet to be examined with regard to his medical witnesses for the grant of any benefit under NCWA, particularly clause 9.4.0. In such circumstances, this repetition is disposed of directly the who constitutes the medical board. Respondent number 4 or 3. Deputy manager personally
Personally, yes.
or respondent number 2.
2 में
जनरल मैनेजर PN IR
जनरल मैनेजर तो नहीं है मेरे पास CMD
Director personal.
Director personal.
Lordship director person, it is the
So
proper
chair-
authority is
Just
general manager PN IR.
the counsel for the respondent has submitted that the competent authority to constitute the medical board is the general manager P and IR, having his office at
Darbhanga House Ranch.
Darbhanga House Ranchi, but he has not been made a respondent in the present case.
Yes.
Accordingly, this petition is disposed of, enabling the petitioner to approach the general manager PNIR of the respondent CCL by filing a representation with all the supporting documents with regard to his medical condition and other relevant materials, and along with a copy of the representation within a period of 15 days from today. 15 days from today, upon filing of such representation, the same authority will consider the demands of the petitioner in the light of the applicable provisions of National Coal Wage Agreement and constitute a medical board for examination of the medical condition of the petitioner within a period of 4 weeks, and get the petitioner medically examined within a period of 4 weeks from the date of representation. Upon examination of the petitioner by medical board, appropriate decision be taken with regard to his claim under the provisions of National Coal Wage Agreement.
one small point. If it may also be observed that if the petitioner is found to be 100% medically unfit, then the benefits may be rendered to the son of the petitioner.
That we will not say.
9 point.
That we will not say.
Yes, because similar coordinate bench has passed similar.
You are seeking a mandamus in anticipation that you will be found medically unfit.
They have examined before me also. Next year, one series is there on hospital certificates.
You cannot declare the order.
No, no, I'm not.
If you are entitled under NCWA,
Yes.
you will get it. If the petitioner is found, if the petitioner slash any of his family members is found entitled for any benefit under the provision of NCWA or applicable guidelines of the respondents, the needful be done by the general manager PNIR within a period of 4 weeks from the date of medical examination of the petitioner, subject to any document or application which may be required to be filed. This representation is accordingly disposed of. You make it final.
I'll make it.
The general manager PNIR is directed to be added
Darbhanga.
at Darbhanga House Ranchi. The entire detail you give.
Yes,
in writing, you put it
POPSL.
Clear words you write.
Yes.
Let the order in any clear.
Respondent number 5, I'll add it.
Is directed to be added as respondent number 5 in writing. During the course of the time. By petition. Do it.
Yes.
Fixed case, item 8 from the list, WPS 177 of 2023.
We had filed the returns. I gave 1 day late yesterday.
The file ID.
They
No,
have filed an
IA
IA.
has been filed on behalf of the
petitioner. That lordship made clear on the last date that no further document should be filed.
No, we have not, therefore we have filed IA not by way of supplementary. We have only sought leave of this Honorable Court to produce the original adoption deed at the time of hearing. Only to that effect.
How do you say that the original is with them? You say that the original is with them?
Yes, that was used to be given, and now also it is given. Whenever we go for a registration, like we get lands purchased, sale deed, that is in accordance with the Registration Act. Then it is a record is maintained in the office, and then it is given. The original is given. Initially, just on the day of the registration, a token which is commonly called as chirkut, that is given, and after some time, when it is entered and all the formalities are done, then the original is given. And he also obtained a certified copy in 2018. That is also made part of that IA.
What is the prayer in your ID?
Prayer is seeking leave of this Honorable Court to produce the original adoption deed at the time of hearing, that is today.
And what is it? RA /?
This is volume 4. The Honorable Court is reading at page 2, para 1. That is.
Not page 2, para 1. I
That's
am at page number 15 of your ID.
Yes, this is IA2 is the one certified copy of the same document which you obtained in 2018. Same document from the Office of District Sub Registrar, Aurangabad. That copy is made part of this IA. The same set registered deed, as entered and maintained in the Office of the District Sub Registrar,
How
Aurangabad.
do we verify this? And in the midst of the proceedings, when the questions are put to you,
Only
why
one,
did you produce it before the authority?
there is only one thing. When the matter will be heard now, I will show that there is no charges or there is nothing that the appointment was made on basis of a plain adoption deed or the adoption deed was produced was not registered, nor they are coming with a plea that they have proceeded on a presumption that a registered deed has been given and it has found to be unregistered. These are not there. And
What is your, let me just see what ID have you filed and what is your relief grade for that. You read para 1 of the ID.
Yes. Being filed on behalf of the honorable petitioner before the honorable court for issuance of an appropriate order and direction for grant of leave to produce at the time of hearing the original adoption deed bearing serial number 1183 dated 25/1/1985 entered in volume 4 as deed number 4 at page number 468-470 in the office of the district sub registrar Aurangabad. And accordingly, this IA may kindly be allowed.
So this particular document you are bringing on record, you are not asking them to produce it through this ID.
Through this IA, because
So you are not asking them to produce.
no,
That you are not asking.
no.
You are producing a certified copy.
The original we are seeking leave, the original and certified copy which
Where
you.
is the original?
It is.
Show us. Let us have a look at the original case. deed itself it is mentioned here कि मुखलियार का उम्र करीब 14 साल किंतु अभी तक अविवाहित है. In the deed itself it is mentioned.
Yes.
So on the date of registration you were 14 years.
The deed was registered on 25/1/85. Deed was registered, and it is the recital. It is the recital is about the year when he was adopted, following the religious.
You just see, you read third page. यह की
यह कि मौका रहेगा
गोलनामा का असर धार्मिक
पढ़िए
हुआ.
पढ़िए पढ़िए आराम से पढ़िए.
हम इसका टाइप कॉपी भी है.
ये उसी से पढ़िए. टाइप कॉपी में तो मिसमैच का बहुत चांस है.
या कि मोकिर अले का उम्र करीब 14 साल का है किंतु अभी तक अविवाहित एवं बिना जगोपवीत का है. तो हम मुकर अले के माता पिता ने धार्मिक संस्कार द्वारा अपने राजी खुशी से अपने लड़के को गोद में दिए. वह इस कार्य को कबूल मंजूरी किए. बाज रहे कि मुकिर व मुकिर अला के पिता आपस में सहोदर भाई हैं तथा एक ही जाति के हैं. किसी दूसरे द्वारा गोद नहीं लिया जा रहा है. या कि गोदनामा का असर धार्मिक संस्कार द्वारा गोद लेने के दिन से ही है. या कि अब गोद संस्कार धार्मिक रूप से संपन्न हो जाने के बाद मोकिर अले मन मोकिर का खास लड़का हो चुका है. वह उनकी कुल संपत्ति चल अचल जो हासिल है या आइंदा हासिल होगा वह कुल संपत्ति वजीन साहू पिता के मोकिर अले को हुआ और तथा उनके मरने के बाद पुत्र का ऐसा अधिकार हासिल हुआ. वो रहेगा. वो बात मरने मनोविकार
It is not referring to any past transaction.
उनका दाह संस्कार श्राद्ध वो पिंडदान.
It is not referring to any past transaction.
And on the charge sheet says that the registered deed is invalid and void for the reason it is not in consonance with the Hindu Adoption and Maintenance Act provisions. Now, this adoption deed from the charge sheet itself it is apparent that this adoption deed was there, and on
That is a separate thing. But this adoption deed is itself indicating that your present age as recorded in the registered document is 14 years, less than 14 years.
now assuming that even assuming that in the given facts of the case, now basically they are trying to review their decision of appointment
That is a separate
after
point.
more than 32 years.
Now let us take it that your age as recorded in the adoption is less than 14 years on the date of registration.
The language, because the recital language is there.
It is very clear. If you are not able to understand
Hana,
Hindi,
and it is not a case of, had it been a case of practicing fraud or forging certain documents, then case would have been otherwise. Fraud vitiates every solemn act. But it is not a case of fraud. The charges are not specifically of fraud. These had the adoption deed not been there with them, the adoption deed was there, and on proper appreciation and verification of the adoption deed, this appointment was given in the year 1989 in terms of their scheme under the National Coal Wage Agreement on an application made by the employee who was declared medically unfit.
would you like to respond to this?
So otherwise, orally fellowship permits me. What he wants is reappreciation of the evidence and taking additional evidence.
He has filed an IA.
I'll file a report.
He has filed the same document,
Yes.
a certified copy of the registered,
Registered.
and he has produced a copy of the registered date for registered.
If fellowship permits,
Really,
Roger, it will not have any impact on the result of the case.
that's right.
Yes.
That should be sufficient.
Yes.
Then there should not be any problem about it.
Yes, yes.
We can just also have a look at this original if you want.
I had seen the photocopy they have filed here.
You can just. This is 10380. What is the date? What is the deed number at the top?
It
1183.
1183.
1183.
One left hand side, one number is there in the first page.
That is the deed number. 1183.
1183.
And what is this page number 15-10380-100? This is a volume number.
That pertains to the certified copy, because it is written in front, the date is 30th March 2018, and it is relating to issuance of this stamp in which the certified copy has been given, because it is in the
The learned counsel for the parties are present. IA number 1810/2024 has been filed in this partnered matter, seeking leave to produce a copy, leave to produce certified copy.
leave to produce original at the time of hearing. That is the prayer. Because that would not have been proper since the hearing has already commenced. Therefore,
Leave
it,
to produce the original deed of adoption at serial number 1183 dated 25/1/1984, entered in volume 4 as deed number 4 at page number 468-470 in the office of District Sub-Registrar Aurangabad at the time of hearing, and the certified copy of the same has been annexed along with the interlocutory application. The learned counsel for the respondents, while responding to the interlocutory application, has submitted that there is no scope for reappreciation of materials on record. However, the deed being certified copy of the original annexed with the interlocutory application, and the copy of which has been produced by the petitioner before this court, there is no serious objection to the interlocutory application. Considering the aforesaid submissions, IA number 1810/2024 is allowed, and the certified copy of the deed which has been annexed along with the interlocutory application is directed to be treated as a part of the main petition. The petitioner will continue to, the counsel for the petitioner is shall retain the original adoption deed for perusal of this court as in when the matter is taken up for final hearing. Actually, when this IA was filed, I did not read it any further. When I saw the IA, so I thought that now a new story is going to be.
Actually, I already prepared the arguments, therefore
Yeah, and we have filed it.
I filed it.
I have also filed it on Monday itself.
The soft copy has also been.
Both soft copy we also given. Soft copy and the judgments also.
Is it for final disposal?
Today it
Since
is
the matter is a partnered matter, post this case for further hearing on Monday.
Lordship, Monday it may not be kept. There is, yes, Tuesday.
Tuesday को हम लोग final disposal में कितना matter है?
Oh, no. Lordship, we keep it on Monday. Actually, one matter of ED is fixed.
Whenever it is convenient to this honorable court.
Every day is on Monday. This being a partnered case, we will take it as a first. 215 as first case. Yeah, आपका है कौन सा किसका है? How do I know who has filed it? Who has filed this?
This one is on our behalf.
Also, humble, we have stated humble list of dates and written notes on behalf of respondent CCL.
Yeah, filed this.
And I have also filed the
There is
judgment.
what is this LPA? Who has filed it?
Lordship, we have filed it.
Is
Lordship,
this a part of your?
yes, LPA, there must be Lordship 3-4 judgments. 2 LPA and 1 Supreme Court judgment. to Supreme Court judgment.
This is on what point?
Lordship, both the LP are on the ground of a Lordship fraudulent employment. And, long tenure of service will have no impact.
You have this 2004 2 SCC 105.
Yes, Lordship.
Other is this LPA number 332 of 2020.
Yes, Lordship.
And
Lordship, another is 2020. 2020 volume 3 SCC page 423 and
2020.
yes, Lordship.
It is not there. You have mentioned it.
Yes, I have mentioned it in my written notes also, and
Where is the list of judges?
Lordships may
There are
see.
so many blank pages in the documents.
Lordship, kindly see page 7 onwards. I have given the reference and I have put it.
This one 2016 SCC online. Jharkhand. And
No,
2020
that is on our behalf.
No, 2016 SSC online we have filed.
Oh, 16.3 we have also given.
LPN number 719 of 2015.
719. Where do
Yes.
I get this LP number?
Lordship, in this judgment only it is there. So,
Okay. Yes, sir. इसके साथ this is another. You have filed 2018-11.
Yes.
Yes, 2018-11 in this side. And this is
And 116.3 SCC.
2016-3.
Lordship, should I give the copy of 2020 volume 3 SSC?
Whatever you have to give, you give it because I will read it and come.
I have quoted it in my, I will give the copy.
You provide that copy and annex it.
Yes.
Problem.
Mr. Das, when you say it is fraudulent, you have to show the suppression on their part,
Yes, Lordship.
right?
From supplementary list, permission item 1 WPS 2767 of 2023.
Petitioner,
Your Lordship, I'm confining at the outset, Your Lordship, my prayer as I've argued yesterday to prayer number 1 only, Your Lordship. Because 2 and 3 will be difficult. Yesterday, Your Lordship said that without working how experience certificate, that is prayer number 2. So I'm just confining to prayer number 1, for which my representation is pending before respondent number 4.
they will take care of it
Yes.
as per the applicable
Yes, Your Lordship.
applicable rules.
Yes, Your
Because
applicable.
there are different rules.
Your Lordship.
Some service rules say from the date of joining, right?
Yes,
So
yes, Your
They have
Yes,
to see the applicable rules.
Yes.
But so far as experience is concerned,
I'm not placing that prayer.
ये नहीं फिर से एक तो नया लिखा है।
नहीं करें ऐसे भी लॉर्डशिप जिस एडवर्टाइजमेंट के परसुएंस में एक्सपीरियंस सर्टिफिकेट मांगे थे ऑलरेडी उसका प्रोसीजर ऑलमोस्ट ओवर होने पे तो नाउ इट इज ऑफ नो यूज फॉर मी
Who is for the respondents? Where is your representation?
annexure 9 series, your lordship, starting from 42, page 42.
You consider this prayer one?
He
Where
is
is the
going to
respondent?
call. He is going to call.
This writ petition has been filed for the following readings. The learned counsel for the prayer number one को आप consider कर लीजिए, बाकी fees not the same. Experience he can't gain by retrospective evidence. This writ petition has been filed for the following reading. The learned counsel for the petitioner, after some argument, does not want to press the relief in connection with prayer at 1 within bracket Roman 2, 1 within bracket Roman 3. The learned counsel has submitted that he wants to press only with regard to prayer at para 1 within bracket Roman 3. The learned counsel submits that the petitioner had participated but his candidature was rejected, and ultimately the petitioner, after long litigation, was granted appointment on 25/2016 after 4 years. He submits that the date of appointment should be notionally taken with effect from 25/7/2012, when the other selected candidates were issued the letter of appointment. The learned counsel has also submitted that the matter relates to direct appointment and the position in the select list will govern the seniority position of it. He submits that there was no latches on the part of the petitioner, and therefore the relief as prayed. Therefore, the petitioner is entitled for the relief as prayed for in para 1 in bracket 1. He submits that no adverse order has been passed in this connection, and he has already represented the respondent number.
4, Your Lordship.
Respondent number 4. The learned counsel appearing on behalf of the state has submitted that since the petitioner was granted appointment after 4 years, the appointment of the petitioner has to be treated from the date of his joining as per his appointment letter. But so far as the grant of any notional benefit is concerned, the same is required to be considered in the light of the applicable rules. She has also submitted that even the effective date of appointment has to be considered in the light of applicable rules. And since no adverse order has been passed, the matter may be directed to be considered by respondent number 4 directly. Director
Yes,
would be best.
Director, yes, Your Lordship. Director.
After you are governed by Jharkhand Service School. You are governed
Yes,
by
yes,
Jharkhand
yes.
Service School. At this, the counsel for the petition submits that the petition is governed by the provisions of Jharkhand Service School. After hearing the learned counsel for the party and considering the nature of relief prayed for by the petitioner, it appears that the petitioner had participated in selection process.
Drilling machine.
जाके कोई बंद कराइए टाइम टेबल है कि नहीं काम करने कोई टाइम टेबल होना चाहिए रात को काम होता है ये सब दिन में काम होता है It appears that the petitioner had participated in the selection process, but on account of certain litigation, but the petitioner was not, but ultimately the petitioner was appointed by on 25/2016 pursuant to orders passed by the school. There has been a gap of 4 years, and other persons who were selected at the relevant point of time were given appointment with effect from 25/7/2012. grievance of the petitioner is that the petitioner should be granted notional benefit with effect from 25/7/20. This court is of the considered view that the relief with regard to notional benefit is to be essentially governed by the provisions of Jharkhand Service Code. And the respondents are required to consider the grievance of the petitioner in the light of the applicable, in the light of Jharkhand Service Code and the applicable rules and circulars. Accordingly, this petition is disposed of, and having the petitioner to approach the respondent in court with a detailed representation along with a copy of the written record and a copy of this order within a period of 15 days from today. Upon filing of such a representation, the respondent will is that raising order considering the applicable provisions and after granting an opportunity of hearing to the petitioner or his authorized representative. The reason order be passed within a period of 6 weeks from the date of representation and be communicated to the petitioner who is request. Mr. Petitioner is accordingly disposed of.
From bail list for finance for item 1, WPS.
The relief in connection with other players, our business has not been.
Item 1, WPS 5166 of 2023.
There are total 3 prayers. And Lords, there are 2 limbs of my arguments. First prayer is with respect to issuance of mandamus for appointment on the trained graduate teacher. Second prayer is respect to show cause the state government as to what decision they have taken in respect of filling up the vacant seats which were remain unfilled by non-joining of several successful candidates. And if the decision is found not rational, conscious, valid, logical, then quash the same, and further the respondent state be directed to fill up the unfilled vacant post by the available eligible candidate. Lords, this entire recruitment process has some history, my lord. The history is that, my lords, in the year 2017, an advertisement was floated.
Satyajit
Yes, my lord, Satyajit. Lords, I will be.
Satyajit Kumar and contempt case.
Yes, my lords. I will be relying upon one important paragraph of this judgment because there is a clear-cut violation of GSSC by publishing the fresh cutoff. Lords, the relevant paragraph is paragraph number 105, which starts from next page, my lords. So 105 is the last page. If I may be permitted to read the whole paragraph, my lord. This was the direction which was.
Could you just tell us, we have read this document.
Yes, my lords. In this paragraph, I have marked the relevant portion, and only 2 lines I'll read from that relevant portion. That what was the direction passed by Honorable Supreme Court. Hence, we are of the opinion that while molding the relief, instead of initiating a fresh recruitment process, if the directions are issued for preparation of fresh selection list based on revised merit list and based on already published cutoff obtained by last selected candidate in each TGT subject.
If there is a contempt of the order of the Honorable Supreme Court, first.
Yes, lords.
Secondly, in the connected contempt petition,
Yes, lords.
there is a clear direction that no order is to be passed by.
Contrary to the High Court. Well, contrary to the Honorable Supreme Court. Yes,
So
lords.
we are not going to pass it.
Yes, I'm not seeking any contrary order from this honorable court, lords. I am seeking
No,
that.
no, anything in relation to this selection process,
Yes.
whatever, ultimately it will, if you are not seeking any, there is a time frame granted by the Honorable Supreme Court.
Yes, lords.
And if we pass any order or
Yes.
any mandamus
Yes.
or anything, that will have a bearing on the selection process.
Yes.
So we cannot.
No, Supreme Court under Article 141 has passed certain direction that you keep the cutoff which has already been published,
No, we will not say.
and they have come up with
No.
a new cutoff.
No, no. we
This is
will
the
not.
issue, my lords.
No, we will not. If there is a contempt of the order of the Honorable Supreme Court, we will.
But Supreme Court is now saying you go to the High Court. They are withdrawing the case, and they are saying that we are not able to
No,
accommodate, my
please
lords.
do not make statements which are not born out of them. We will not, we cannot interfere. You see, these things has to be taken to a logical end.
Yes.
There is a purpose by which the Honorable Supreme, for which the Honorable Supreme Court has specifically recorded. Normally, Honorable
Yes.
Supreme Court does not record such a
Yes.
direction.
Yes.
That the High Court will not pass it.
Obviously. This was the purpose, my lords, that
That this
there's
has to be come to a
logical
quietus.
end, my lords. There are 17,000 seats are there. 4,000 seats are remain unvacant. Under right to inform, I filed a supplementary
You just
affidavit.
tell us one thing. This is of the year 2016.
17 it was amended.
No,
17 it was
2016 original advertisement.
original amended in 2017.
Now you see the situation.
Yes, my lords.
You want the process to continue with respect to the candidates who had participated and applied pursuant thereto.
Yes.
How many years have passed?
More than 7 years.
Now what will happen to new eligible candidates?
New rules has already come, my lords, and
No,
now it has
therefore-
converted to
therefore,
Acharya teacher, my lords. This
Whatever it is, therefore, the recruitment process should end such that the new candidates, the fresh blood is also given an opportunity.
they are already done, my lord. Advertisement is there. They are giving the examination. 26,000 posts have been created, my lords.
Creation is another
No.
thing.
Advertisement has been floated, my lords, and recruitment process is going on for the fresh teachers.
Very good, you participate there. Where is your problem?
But, my lords, they are not complying the order of Honorable Supreme Court, my lord.
Please go to the Honorable Supreme Court. We will not issue contempt orders.
At least, my lord, something that why they have come up with that new cutoff.
No, we will not say. WPS number
My lord, second,
5166
with respect to
of
second and third prayer, my lords, with respect to seats, my lord, there is a
So
direction.
We will not pass any order. You just tell us how do I overcome that observation of the Honorable Supreme Court that this court
No,
does not pass any order in connection with the conduct.
Supreme Court has said, my lords, in its order that prepare a merit list on 17,000 posts. They have not prepared the 17,000 posts, my lords. Seats are lying vacant, my lord.
Where is that contempt order?
Yes, my lords, I will next. It is at page number 47 onwards, my lords. 48 is the relevant, my lords.
We have passed certain orders. I will just copy paste from that, arising out of the same. We have refused to interfere. So relevant portion of these orders, these judgments will be quoted there.
Yes. And with respect to, my lords, unfilled posts, my lords,
I will not make any observation.
they are not filling up the posts, my lords. They are
WPS
not.
number 5166 of 2023 for the learned council for the parties. The state petition has been filed for the following reading. The learned council for the petitioner has submitted that the respondents are now following the directions of the Honorable Supreme Court in letter and spirit. He has further submitted that there are unfilled posts and steps are not being taken to fill up posts.
Yes, my lord.
The learned counsel for the respondents by referring to the judgment passed by the Honorable Supreme Court in the case of Satyajit Kumar and others versus State of Jharkhand and others.
As well as in contempt case number 612
And in contempt case number 612
of 2022, that is page 46.
ये सत्यजीत कुमार का है in civil appeal number 4038 of 2022 and other analogous cases dated 2nd of August 2022 and the contempt case
Page 46 of also.
612 of 2022.
contempt case number 612 of 2022
In
in
civil
Soni Kumari versus K. Ravi Kumar dated
15/12/2022.
dated 18/12 15/12/2022 and has submitted that the process was to be continued in terms of the various directions passed by the Honorable Supreme Court and while disposing of the contempt application, the Honorable Supreme Court has clearly observed that the
Page 48 you got see.
yes,
And 49 at top.
that page 48.
49 on the top.
And 49 at top. It is also made clear that High Court has not.
Has clearly observed that as under inverted comma, it is also made clear that the High Court shall not pass any contrary order with respect to the recruitment in question in inverted comma. The learned counsel submits that if any direction as prayed for in the state petition is passed, the same will have that same will be in violation of the orders passed by the Honorable Supreme Court and would amount to extending the period as prescribed by the Honorable Supreme Court. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that rest of the findings are in connection with the correct same. Dismiss case sorrow is due. It is under correction.
Item 2, WPS 76 of 2023.
Your Lordship, as a short pass over may be granted in the concerned lawyers against court number 16, Your Lordship.
The notice has not been served. You are supposed to file a supplementary application.
We have filed that. And the notices went to private respondent, who is the husband of the petitioner.
He's not appearing.
He is not appearing. On the last occasion, there was a direction for him to file the requisite.
What was the last
It was on 13 to 24 minutes. No, or 5 to 24.
Who is the officer in charge of the concerned police station? Anybody for the state? There was an order to serve notice upon respondent number 4, who is the officer in charge of the concerned police station. The state is not a party in the proceedings. Your state is not a party, but you seek instructions from the officer in charge of the concerned police station and file it. Okay? आपको सब चीज मिलेगी.
My lord, इसमें CMPFO भी एक required party because the petitioner, the respondent, private respondent has already superannuated. तो pension या जो भी है that is.
Let them just first let respond number 4.
Yes.
Counsel for the parties are present. As per the office note, the notice was issued to respondent number 4 to be served to the officer in charge of concerned police station, Dhanbad, fixing the date as 21.02.2024. But the affidavit of the concerned police station, officer in charge of the concerned police station, has not been filed, nor the service report has been forwarded by the officer in charge. Mr.
Shubham Gautam, AC to AG5.
Shubham Gautam, AC to
AG5.
AAG5 is present in the court. The officer in charge of police station Dhanbad, he is directed to seek instructions and file an affidavit of the officer in charge of the concerned police station regarding service of notice upon respondent. All the orders are uploaded, right? The petitioner is directed to serve one copy of the entire records of this case to the learned counsel who is appearing in the. How much time do you need? Close this case on 19th March, awaiting the affidavit of officer in charge of concerned police station.
Item 3, WPS 97 of 2023, along with item 4 to 6.
In this case, my lord, I am on behalf of respondent to ICAR, but copy has not been served to me, my lord.
Respondent number 2.
2 yes, ICAR, but copy has not been yet served.
After serving the copy, this writ is mentioned, admitted by the office.
This is
So, after serving the copy to the respondents, we have pleaded as a party. So then only this writ petition has been accepted, and if not, we have served the copy. The defects are there. After removal of defects, only this comes for the fresh filing, and then thereafter, after the issuance of the notice, then admission will be issued.
You want your matter to be taken up, or you want to fight on the service of copy?
No, not.
अपना नाम बताएं.
TN Misra.
TN. Have you filed वकालतनामा?
No, my lord.
Why not?
No. Actually, they have not given me copy.
So?
After waiting from the headquarter, I will file a wakalatnama.
You have received
My
instructions?
name is already been given in RD.
Have you received instructions?
Yes, I have telephonic information. They have.
They have instructed you
Yes,
to receive
yes.
copies?
Yes.
We'll record. Who else? Other respondents have filed counter?
Yes.
All other respondents have filed counter? No private party?
No private.
You have filed the rejoinder?
I am filing. In all the 4 cases.
In all the 4 cases,
No.
you are respondent number
Yes,
2?
yes, ma'am.
There is one case where the notice has not been served upon respondent number 4. Service report of respondent number 4 is not received. Notice was issued upon respondent.
Respondent number 4.
It's the Vice Chancellor Birsa Agriculture University. They have already
For
filed a
university,
contract.
we have
Learned counsel for the parties are present. Mr. T. Mishra advocates submits that he has received instructions on behalf of respondent number 2 in all these cases to appear in these cases, but he does not have a copy of the deputation. Counter affidavit has been filed. It has been submitted by the counsel for the parties. That counter affidavit has been filed by all other respondents. And
university.
we do not know. You said that it has been filed.
We are investigating.
Sorry? State is common in this unit. We do not know. You want to file or you don't? It is your choice.
No, we have filed in one case.
In one case.
I mean serial number 3 and 4. One case I have filed.
6 also counter affidavit on behalf of state is filed.
You want to file your counter affidavit or you don't want to file?
We filed.
You have filed it. You have all filed it.
If you have not filed your lordship, you can adopt it for 3 and 4.
Serial number 5. Serial number 5 is which case?
Serial 99, WPS 99 of 20.
The counsel for the respondents has submitted that counter affidavit on behalf of the other respondents had been filed in all other cases except that WPS in WPS number 99 of 2023, the state has not filed a counter affidavit. At this counsel for the state has submitted that no separate counter affidavit is required to be filed in WPS number 99 of 2023. As similar issues are involved in the present case, she would rely upon the counter affidavit filed in the other cases, to which counsel for the petitioner has no objection. So far as respondent number 2 is concerned, the counsel for the petitioner is directed to serve 2 copies of each of the petitions by Monday. The respondent number, counsel for the respondent number 2 is directed to seek instructions and file counter affidavit in each case by 12th of March. Rejoinder by 19th March, post on 27 under the heading publication.
7, WPS 151 of 2023.
This relates to compassionate accounting leadership needs in last order, my lord.
Lordship, the judgment that I
Last
relied
order,
upon,
you
Your
are
Lordship, I am withdrawing
You
it.
are relying upon a judgment passed by the Calcutta High Court, my lord. I have judgment of the Honorable Supreme Court where that judgment has been duplicated.
Yes, Your Lordship, I am withdrawing, Your Lordship, that judgment, Your Lordship.
My lord, your lordship may sit.
I have filed counter request. The writ is not maintained in view of the fact earlier when the petitioner had filed writ application of two grounds. One, connection of the respondent to give a compulsory appointment to son, and another, my lord, to give retirement benefit.
I am the petitioner.
Same has been after argument, my lord, learned honorable court.
You have filed a counter affidavit or you have not filed?
Filed.
Pleadings are complete?
Yes.
Now you don't want to rely upon this judgment
The previous judgment, the Calcutta High Court judgment, Your Lordship, I am not relying upon.
because of the fact that it has been deputed.
It has been considered by Honorable Supreme Court, Your Lordship, because this judgment was passed without considering the previous judgment of Honorable Calcutta High Court, which was followed by Madras High Court and
Para 19 of this.
Para
Therefore,
19.
whenever you see,
Yes.
you cite judgments of any high court, the fact check is required to be.
Yes, sir.
This is absolutely reckless.
In fact, it's a contempt.
We will not term it as contempt, but it is absolutely reckless.
Yes.
We could have passed an order based on that judgment.
Para 19. May I take a lawsuit? We may note that at this stage that the division bench of the Calcutta High Court in such and such quashed the circular of the Railway Board dated 2nd November 92 to the extent that it prevented the children of the second wife from being considered for appointment and compulsion ban. Subsequently, another division bench of this High Court in decision in Eastern Coalfields versus Dilip Singh, the judgment he was relying on, took a contrary view without noticing the earlier decisions. We may advert to the subsequent decision in Eastern Coalfields Limited for the reason that it proceeds on a construction of section 16 which in our view is inconsistent with the language of that provision. The division bench held thus.
So the matter ends now?
Yes, sir.
That judgment, Your Lordship, I am not relying.
Counsel for the parties are present. Pleadings complete?
Yes, sir.
The learned counsel for the parties submit that the pleadings are complete. The learned counsel for the petitioner has submitted that the judgment which has been relied upon by the respondent passed by Honorable Calcutta High Court as mentioned in order dated 5/2/2024 has been considered by the Honorable Supreme Court in judgment reported in 2019 that it was 14 SCC 646 and contrary view has been taken. At this counsel appearing on behalf of respondent Eastern Coalfields Limited submits that he shall not rely upon the judgment passed by Honorable Kolkata High Court, which has been referred to in the earlier order. However, he submits that he still has a case.
Yes.
List of
My-
dates वगैरह find किए हैं। ऐसे नहीं कर सकते हैं without list of dates we contested matters we can't. Close this case for it is for findings.
Final.
Fine.
It is for findings.
Yes.
Yeah.
Final.
Close this case
Sir,
under the heading of findings.
Admission में.
On next Wednesday को कितना matters है? Wednesday.
हम लोग सिर्फ पैराग्राफ 9 of our counter affidavit we are relying that there are.
I will reserve my arguments for the next one.
Yes, yes.
The parties to file their list of dates, notice of parliament, and the judgments which they seek to rely upon by Monday. और आप लोग से एक ही रिक्वेस्ट है प्लीज ड्यूरिंग द कोर्स ऑफ हियरिंग लिस्ट ऑफ डेट्स इज मत फाइल नहीं तो हम कॉस्ट लगा देंगे it is not proper, during the course of hearing you file something. Not proper. You don't even give opportunity to the other side to go through it. submit the documents.
उधर हाथ that side में lift.
इस कैलेंडर को यहाँ से हटा दो क्योंकि this is creating problem.
Item 9, WPS 257 of 2023.
Malad, in the last occasion, the council of the respondent had praised for helicopter.
Your Ladyship,
Actually, in this case, my lord, the petitioner praised for direction upon the respondent to consider the candidature of the petitioner for appointment in the on the post of part-time some staff, 1/3 scale wage due to reason that the petitioner has already.
The file you counsel.
Your Ladyship, I am praying for not today. It will be filed by tomorrow.
Counsel for the parties are present. Counsel for the respondents submit praise for and is granted time till day after tomorrow to file a counter appeal on the present case. Close this case and then.
My lord, in this case, my lord, the similar issue, my lord, is also involved in the one writ application 1798 of 2023.
1798.
उसी काउंटर से उधर हो जाता है.
देखिए तो 1798.
1798 of 23.
Just a moment.
रंजीत कुमार दास.
What is the stage of that case?
वो बना डिफेक्ट फ्री हुआ है. डिफेक्ट फ्री.
It is against the same man.
Same list, same. ये रैंक ऑफ 21वां नंबर इसका है, उसका 11 नंबर.
आपका लवाजमा
क्लियर कर दिए हैं एक हफ्ता पहले. जी हो. इसके साथ जो
इसको डिसाइड कर देंगे उसको फॉलो करें. Who is this case under the heading for final disposal on matters? Rejoinded in training by Monday. मुझे करना rejoinded. अगर कुछ करना होगा.
Item 10, WPS 364 of 2023.
Sorry. Readings complete.
Married for washing.
Readings complete.
For washing already order dated 13/1/14. That is my lord, annexure 4.
Annexure 4.
The petitioner has been dismissed from service as he has been convicted in a criminal case.
There is the order of dismissal.
Order of dismissal is my lord, annexure 4, page 20.
That is subjected to disciplinary proceedings or no?
My lord, during this petitioner was issued suppose notice, and that time this aforesaid notice had been served when he was in custody, in jail. And due to being detained in jail, he could not participate in proceeding. This is the only ground.
Where is the show cause?
That is my lord.
Arop Prarup, annexure 2. Right? What is your period of custody?
10 years. Custody is my lord, 10 years.
From which date?
10 years. Arrived for 10 years. Under section 676.
From date
21 to 13.
Sorry?
21 to 13.
21 to 13 to
13. He was in custody. The judgment had been passed.
I'm just asking you the period of custody. From which date to which date?
Period of custody after conviction 10 years should be completed.
After conviction.
Madam.
Which is 21, 3 23.13. During the trial, you were on bail.
During the trial, petitioner was on bail. He was on bail.
His charge sheet was issued when 5/12/13. So you did not participate in the disciplinary proceedings.
Your ladyship, in this counter we have mentioned Honorable Court has rejected his bail application.
That is why he was in custody.
He was granted bail.
So he was in custody during this.
I apologize.
He was in custody. He says that he was.
He's still in custody, your lady.
He's still in custody. Are you still in custody? 10 years has elapsed. 10 साल तो हो गया. अब तक छूट गया.
He's on bail now. Now he is bail. He has been granted bail, my lord, by this honorable court. I have the order.
You did not participate in the disciplinary proceeding.
No one.
What was the allegation? Read your charge sheet. Page number 26. Padi.
Page number 22.
26.
22.
26. Annexure 2.
आप शादीशुदा होने के बावजूद भी एक अन्य महिला फुलमणि मुर्मू पिता सचिन सर मुसावनी अवैध रूप से शादी का प्रलोभन देके 2 वर्ष तक उस महिला का शारीरिक यौन शोषण करते रहे। वादनी की लिखित प्रतिवेदन के आधार पर आपके विरुद्ध राजनगर थाना जिला सरायकेला खरसावां कांड संख्या 24/2010 दिनांक 1/7/10 धारा 420, 494, 376 भारतीय दंड विधान अंकित कर मुख्य अभियुक्त बनाया गया। कांड में जब आप न्यायिक अभिरक्षा में मंडल कारा सरायकेला खरसावां में थे तो इसकी सूचना आपने विभाग को नहीं दिया। कांड में आपको माननीय न्यायालय 10,000 रुपया अर्थदंड और 10 वर्ष कारावास दी जा चुकी है। इसकी सूचना पत्र संख्या 1065 डेटेड 2/12/13 के संलग्न एडिशनल पब्लिक प्रोसिक्यूटर झारखंड उच्च न्यायालय रांची के पत्र 29/11/13 के द्वारा प्राप्त हुआ। इस प्रकार यह स्पष्ट है कि आप गलत नियत से सेवा में बने रहने हेतु माननीय न्यायालय के आदेश एवं अपने न्यायिक अभिरक्षा की बात छिपाई है। अन्य महिला के साथ अवैध रूप से प्रलोभन देकर के शारीरिक शोषण करने के हेतु आपके विरुद्ध विभागीय कार्रवाई के तहत आरोप प्रारूप गठित किया जाता है।
आपको तो जेल में सर्व हुआ है। It was served to you in the jail.
He was in custody. That period the notice was issued.
You were not served with this.
It is admitted that in the counter affidavit also.
He was not served with this.
It was served and your
Must have been served.
It has been served, your ladyship. It was totally by we have given in para 8 also that departmental proceeding was initiated against him, and wherein after the conclusion of the inquiry, the conducting officer on 8/10/2014 they have submitted the report that finding that the petitioner is guilty and he has been that exploited the victim and he did not
dismissed. Otherwise,
he has been dismissed.
Convicted, he will stand dismissed.
He was dismissed. As we have already annexed the report in Annexure C, your ladyship, that is page 19 of the counter.
ये जरा पेज नंबर 28 का बॉटम पढ़िए तो अपचारी द्वारा पढ़िए। अपचारी द्वारा केंद्रीय कारा पढ़िए पेज नंबर 48 Annexure 4 बॉटम। पढ़िए
28.
Page 20.
20.
Page 28 bottom.
मत औपचारिक द्वारा केंद्रीय कारा घाघीडी जमशेदपुर के पत्रांक 26 से 43 जेल दिनांक 21/12/13 के माध्यम से समर्पित स्पष्टीकरण का अवलोकन किया, जिसमें इन्होंने उल्लेख किया है कि कार्यालय के द्वारा 15/3/11 को बहाली ड्यूटी के प्रतिनियुक्ति किया गया था। अचानक इकबाल से पता चला इनकी मां की तबीयत खराबी के कारण घर आना जरूरी था। इसी स्थिति में असमंजस में पड़ गए और सूचना नहीं दे पाए। यह दिनांक 18/3/11 को कार्यालय में योगदान देने के लिए आए। उसी दिन इन्हें न्यायिक हिरासत में लिया गया। इन्होंने उल्लेख किया कि इन्हें साजिश की तरफ फंसा दिया गया है। ये न्यायिक हिरासत में है। इस मुकदमा के विरोध करने में झारखंड उच्च न्यायालय में अपील किए हैं, जमानत याचिका दायर किए हैं। जमानत मिलने पर कार्य में योगदान देने की किए हैं। इस प्रकार अपचारी ने स्वयं स्वीकार किया बिना सूचना के सक्षम पदाधिकारी की अनुमति के मनमाने ढंग से अपने कर्तव्य के अनधिकृत रूप से फरार है।
You did not take leave and
After conviction, as per the law, he was taken into custody to serve the rest of the sentences. Thereafter, he remained in custody. And
did you
during
inform them
that
about
period,
your case, about grant of your bail during trial? Did you inform them that such a criminal case has been filed against you? This is the charge, that you have not informed them that a criminal case, a serious criminal case has been filed against you and you have been granted bail.
that was only during the service period. The ground is dismissal is my conviction.
No, the ground of your dismissal is not conviction. The ground of your dismissal is that you did not inform the authorities that there is a criminal case pending against you, and then you have been granted bail. This information was not ever given to them. This is the ground in the disciplinary proceedings. Isn't it?
Yes, Your Ladyship. Has the ill intention to remain in the service despite of the fact that he has been convicted in the criminal case.
ये मेरे चार्ज जो हुआ है, चार्ज में ये स्पष्ट है कि गलत नियत से सेवा में बने रहने और न्यायिक अपेक्षा की बात छिपाई, अन्य महिला के साथ अवैध रूप से प्रलोभन शारीरिक आरोप, but he could not be provided opportunity to defend his case. Yes, he has. I have submitted in my writ application that I was in custody during that period.
Opportunity was given, Your Ladyship.
But in custody, how will you avail of it?
Your Ladyship, charge was framed on 6/12/2013 and the petitioner has sent his explanation through Central Jail on 31/12/2013, Your Ladyship. So, already department has given chance.
And my lord, I also
and it is an admitted fact that he was already into judicial custody.
I may also be permitted to submit, since a disciplinary dismissal is a major punishment. Therefore,
After conviction, can you be retained in service? Otherwise also?
But
unless that conviction is set aside, you cannot be taken back to
that is
service.
another thing, that is not the charge.
So we are just thinking to exercise power under 226, because as it is you have been convicted and you have only been released on bail and convicted in connection with your colleague. Allegation is in connection with your colleague.
That is.
Colleague, है ना? You say departmental proceeding and criminal case are not the same and identical facts, no? That is not correct. Under which provision of law is he supposed to inform you regarding any kind of criminal case filed against him? Is there any provision?
is convicted.
Prior to conviction, if there is a criminal case filed against him, then is he supposed to inform?
Yes, Your Ladyship.
He is not even giving the period of his custody. आप बताइए पिटीशन में आपको पीरियड ऑफ कस्टडी कब से कब तक है? You will not give your period of custody, and your silence in the garb of silence is not an order.
I was granted bail during.
You just tell us what is the period of your custody date-wise. I'm sure that in 376 you might not have been given anticipatory bail.
No.
So I want to know. Counsel for the parties are present. Upon a query of this court, the counsel for the petitioner is not in a position to give definite date during which the petitioner was in custody in connection with the criminal case. From the perusal of the charge memo, it appears that the petitioner that the allegation against the petitioner was that he did not inform the respondents regarding pendency of criminal case against him, and ultimately he was convicted by judgment dated 21.02.2024, a copy of which has been annexed along with the writ petition. It is a case of the petitioner that proper opportunity was not granted to the petitioner during the departmental proceedings as he was in custody. However, from the perusal of the records of this case, it appears that the petitioner had filed a show cause reply from jail. A copy of the show cause reply has also not been annexed along with the writ petition. The counsel for the petitioner is directed to file a supplementary affidavit bringing on record the show cause reply which was filed by the petitioner and is mentioned in the interim order, and also gives specific date with regard to his period of custody. The affidavit should also accompany the copy of the bail order during trial and after conviction. Let the supplementary affidavit be filed by 5th of March, post on 13th of March 24. This is for final discussion.
This was an admission.
Post this case for final discussion.
Your Ladyship, can it be taken up after 13th?
After 13th. You want before 13th also?
No, I'll be not there on 13th, Your Ladyship. After 13th.
12th you are there?
Your Ladyship, for 3-4 days.
18th of March?
Item 11, WPS 1770 of the 2023.
To file counter affidavit, madam. I'm sorry, but it could not be filed. I was paying for 2 weeks' time by way of last transfer.
Learned counsel for the parties are present. Learned counsel for the
Bank.
I'm also praying
For the bank.
prayed for and is granted respondent bank.
Yes.
for state also.
State is also.
State also. I'm also praying for that.
Learned counsel for the respondents pray for and are granted time till 1st March to file the counter affidavit in the present case by way of
Could it be
last
one more
week.
week? Could it be one more week?
7th month by way of last indulgence to file a counter affidavit in the present case, rejoinder by copy, post on 20th March. And the deadline for final disclosure.
Item 12, WPS 2382 of the 2023.
This is the petitioner placed before the Supreme Court for issuance of the writ law for quashing the Army Command Order number 65 2023, read with memo number such and such dated 29/12 under the signature of the district commandant Jharkhand, that is Annexer 7, my lord. My lord, in this, my lord, after the death of my lord, the petitioner husband was a home guard, and he succumbed to injury, my lord, and he died, my lord, and on that ground, my lords, petitioner was appointed on compassionate ground, enrolled as a home guard, and he was given training in computer, and he was working as a computer operator in home guard. After that, my lords, by Annexure 5, my lords, one so-called notice was issued, my lords.
Punishment has been imposed on you.
My lords, that is Annexure
You have
7.
exhausted all the remedies. All the
Yes.
internal remedies have been exhausted.
Yes, my lords.
Appellate order is also on record.
No, that is not.
You did not file appeal.
No.
There is no
No.
provision of appeal.
No, my lords.
There is no provision of
Home guards में ऐसा नहीं
होम
है।
गार्ड्स में
No है।
I don't know. You must be knowing that. We are not governed by
No, police manual से
पुलिस
नहीं।
मैनुअल में
Home guard rules अलग
There
है।
is no provision of appeal. Should I note it?
appeal home guards they cannot prefer appeal, your lordship.
So they have the only remedies given to appeal.
Home guard they cannot prefer appeal, your lordship.
Where is the room?
Yes, home guard rules.
Where are the home guard?
Your ladyship, in 2004 there is an provision, it has been come, home guard ka rules. We'll verify that, your ladyship.
Regarding alternative remedy?
Yes, your ladyship. Yes, yes.
Counsel for the parties are present. Can I post it tomorrow? Should I post it tomorrow?
Your ladyship, Monday.
Counsel for the respondents. The counsel for the parties are directed to seek instructions and inform this court as to whether the petitioner has any alternative remedy of appeal against the impugned order. Post this case on Monday. For orders. If it come for orders, so that is taken up. I can request.
Item 13, WPS 3024 of 2023.
Madam, the rules of Anganwadi Sevik and some judgment relied by the respondent number 6. Well, so I've got the rules, the present rule and as well as the new rule. Both the rules are there, madam. And the judgment relied by the private respondent, wherein the honorable right from the apex court, which has dealt that the Anganwadi Sevika post is not a civil post. An application of constitution is not available to them. And even the coordinate bench of this honorable High Court have not interfered in such matters, my lords. All this judgment have brought on record, my lords. First, the second judgment may be seen, my lords. Just paragraph 8, bottom, 4 line from the bottom, my lords. 2. Paragraph 8. Bottom, 4 from the bottom, my lords. The person, yes. Savita Devi versus State of Married. Para 8. Yes, bottom from bottom, fourth line. The person working as Anganwadi Sevika, workers did not hold the civil post. Their application is not maintainable. The post of Anganwadi worker is not a civil post, which are created under scheme. The Anganwadi workers did not carry any function of the state. No recruitment rules are followed in the appointment. The recruitment process is not governed by the constitution or any statute. They are not the posts created by the central government or the state government in exercise of powers under Article 77 and 162 of the Constitution of India. Rules framed under Article 309 are not attracted in the cases of Anganwadi Sevika. The Anganwadi Sevika are free to contest elections, whereas holders of civil posts is not entitled. Parity in employment with regard to civil posts cannot be allowed in case of Anganwadi workers. Further, paragraph 29 is to be seen. Appointment made under the scheme and recruitment process in that same page, page 3 itself, paragraph 29.
appointments made under the scheme and recruitment process being carried out through a committee, in our opinion, would not render incumbent thereof holders of civil post.
Does it say that the repetition is not?
Yes, my lords. In the other next judgment, Saroj Kumari, third one. The second page of the judgment, Mr. Rahul Saboo, the learned counsel for the respondent state, submit that Anganwadi Sevika is not a civil post and this court may not interfere under Article 226 of the Indian Constitution. He submits that the Deputy Commissioner is competent authority to look into such grievances. And he has done so. In view of the above facts, the Deputy Commissioner is directed to look into the matter. The petition
And they themselves had gone, they had filed the report.
But there was.
Is this not contradictory when you say this?
The rules is to be seen now, Malik.
There is an appeal.
In the new rules appeal. In the new rules appeal has been forwarded.
In the earlier rule also.
Lordship, what my learned friend is making a submission that rate is not maintainable. They themselves earlier had preferred a writ petition, for which.
You are for the private response.
Yes.
It was 2026.
So you had filed the writ petition earlier?
Yes.
Writ petition was entertained?
It was entertained with a direction to approach the DC.
That's right.
Yes.
But it was entertained?
Yes, it was.
The direction was issued?
Yes.
A mandamus was issued?
Yes. It was entertained and it was there was a direction to approach the concerned Deputy Commissioner.
So do you want to close the door of 26 for Anganwadi for all times?
Your Ladyship, I just wanted to point out.
The role of one or the other state authorities there.
Yes.
Maybe that they are not entitled for regularization. Maybe that they are not employees for 311. Maybe that they are not employees for 309. These things may not apply.
May sir.
But any arbitrary action
that
on
can
the part of the
that
state.
can be.
So that forms a different conclusion.
Yes, that can be. The only point I was trying to impress upon before this honorable court was that the Anganwadi Sevika post is not a civil post. Henceforth, Article 16(4) and that reservation policy will not be applicable.
It is in the scheme only. Reservation is provided in the scheme only.
Rules may be seen, my lords.
They are working under the scheme, no?
They are working under the scheme.
If your Lordship, for a moment, if it turns to Annexure 3 of my petition,
What is your relief that you are seeking? Who is
The
for the trial? You are for the trial.
Yes. Respondent
You
number
are
6.
filing your counter affidavit?
No, man.
You are filing, you are want to.
Yes,
so
I want
all
to.
the facts stated in the
Yes, it has been
taken as correct.
Yes, it has been stated since they have challenged the order of their termination, which is as Annexure 3, my lords. They agree with that order, and that order is very specific, my lords. Even all the petitions.
See, you can't have both ways. I will not permit you to file a counter affidavit once the argument begins.
On the last day, they had said that they will not file counter.
And on the last day, they said that
They said he doesn't need to file a counter. On the last day, he had made a submission. If your Lordship permits me, your Lordship, I want to take the factual aspect of the case, and thereafter, your Lordship, on the last day, had framed a question, a law point, your Lordship.
Yes.
If your Lordship. For a moment, if your Lordship permits, I'll just apprise your Lordship with the fact of the case, your Lordship, and thereafter, I'll also place some of the judgments to assist your Lordship.
Let us see the scheme. The point is formulated on the last page.
Only I want to, one more fact, your Lordship, I just want to show your Lordship. Annexure 3, page 30, your Lordship, the last order. How they are suppressed before this court, your Lordship, before this court. Annexure 3, page 30, your Lordship, has what? By filing of this petition, the petitioner has approached this court for her appointment to the post of Anganwadi Sevika at Anganwadi Center, Bandura District, Palamu. It is the case of the petitioner. The petitioner had participated in the selection process and she is more qualified than the other candidates, but till date, the result has not been published and none of was selected. However, if your Lordship, Annexure 2, if your Lordship will see, on 30/8/2022, my appointment was given by, I was given my appointment. That has been suppressed by them. Thereafter, the court says, I direct the DC Palamu to look into the grievance of the petitioner and conclude the process of appointment, such as within 6 weeks from the date of receipt, if not already concluded. However, they suppressed before this court, and DC also did not look into the fact that I have been already, rightly or wrongly, I have been appointed.
So your selection was not under challenge?
No, your Lordship, they
had.
had. In earlier, no. They came to this.
WPS number 5132.
Your Lordship, it's 13/10/2022. 13/10/2022. After my date of appointment. They are suppressed before this court.
Malice, in the same order, there was a direction to the state to file counter. They have not filed, and that this order was without them being filed in the counter. This order was passed, and the petitioner was not aware of the fact that someone else has been appointed.
Supposed to disclose all material facts to the court.
Yes, that indeed,
Right?
Malice, but
Irrespective of any contract.
yes,
Isn't
indeed,
it?
indeed. But the fact was, at that point of time, the
Have you
petitioner.
stated in your petition that this fact was suppressed?
No, Your Lordship, this actually this point I was going through yesterday. The brief that's there.
You can't have points like
However,
this.
Your Lordship, from the
Because had it been there, they would have responded that they had no knowledge.
but Your Lordship will see from the order dated and the appointment dated. Appointment dated is much prior annexation to my.
Maybe that they are not aware. Communication is one thing, passing of another, the order is another thing. Both are not one and the same. Please do not make any argument which is not based on it. When you are alleging that there is a suppression, there has to be a specific allegation that there is a
It is much clear with the annexations itself, Your
I
Lordship.
don't know, it may be clear to you, it is not clear to me.
Your Lordship will see annexation 2 for a moment.
I've seen it.
The order, I was appointed much prior
From
to
where
his
you say
appointment.
that they knew about it.
How will they not know, Your Lordship? They live in the same district, they are challenging the writ petition. Thereafter, on the same day, 13/8, Your Lordship, they will not know.
Which college have you passed out? I need to ask you.
Lordship, but this is the actual fact in the
I
state.
just want to know.
Amity Law School, not Kalyan. But however, in the same district, if they are residing, ma'am, Your Lordship, they.
May refer para 12 to read. Para 12. Just the government is that the petitioner states that meanwhile respondent number 6 has filed a writ petition bearing number so and so, being agreed by the appointment of the petitioner on the post of honorable. Being agreed.
That was under challenge?
So therefore, the writ, they are saying it is not under challenge. The respondent number 6 says so. I have filed it before knowing that she has been appointed. The petitioner says so that it has been agreed. Therefore, they have filed it.
But that is not the relief prayed
No.
for in the petition.
That's only may indicate few things. Not very important. Thus, in this matter, even if the honorable court has directed the DC concern to.
No, we will decide the crux. The issue we will decide. You forget about all this. We are not with you on this.
The notification, Your Lordship, the notification has to be challenged by them. The notification, the annexure 4, if Your Lordship will see. Circular.
Where is that circular?
It's annexed.
Circular.
The annexure. It's annexure 2. Annexure 5, I'm sorry, Your Lordship. Annexure 5, page 33.
Page 30.
Has Your Lordship put it?
Yes.
Clause 10, Your Lordship, the relevant question. May I permit you to read this? आवृत श्रेणी के अनुसूचित जाति, अनुसूचित जनजाति एवं केंद्र अन्य पिछड़ा वर्ग के सदस्यों के जाति प्रमाण पत्र हेतु गृह मंत्रालय भारत सरकार के पत्रांक सचिन सच STG दिनांक 22/3/1997 एवं पत्रांक सचिन सच BCDI दिनांक सचिन सच तथा कल्याण मंत्रालय नेक्स्ट पेज भारत सरकार के पत्रांक सचिन सच दिनांक 8/4/1994 प्रासंगिक है, जिसके अनुसार जाति प्रमाण पत्र निकृत करने हेतु किसी व्यक्ति के किसी स्थान विशेष के होना महत्व रखता है। शिक्षा ग्रहण करने, आजीविका प्राप्त करने अथवा अन्य उद्देश्य से कई व्यक्ति दूसरे राज्य से आकर बस जाते हैं। ऐसे लोग अवरजित श्रेणी माइग्रेटेड में आते हैं और इन्हें अनुमान्य आरक्षण की सुविधा इनके मूल राज्य में ही उपलब्ध होगी। झारखंड में आरक्षण की सुविधा नहीं मिलेगी। इसी प्रकार यदि कोई महिला विवाह के आधार पर किसी अन्य राज्य से झारखंड के आवरजित होती है तो ऐसी महिला को अनुमान्य आरक्षण की सुविधा उनके मूल राज्य में ही उपलब्ध होगी। That means in the parent state, in a parent state. Now, if your lordship will see our constitution.
You see, these circulars are in the, for the purposes of issuance of caste certificate.
Issuance of caste.
Yes. You see, if a person originally belongs to Chhattisgarh, and married in Jharkhand, then under such circumstances, her caste status can be decided only by the authorities at Chhattisgarh, who would conduct the necessary inquiry and issue the caste certificate. That does not mean that she will cease to be belonging to a particular caste in the state.
DC had seen the caste certificate of her and thereafter had.
Where is your caste certificate? It has been issued by which authority?
Page 31 and 32 is clear.
Everything is not against you. Yes, where is your caste certificate?
It is not on record. It is not on record, but the DC has held that.
You don't want to file a complaint. You are in a hurry. When I want to see a caste certificate, it is not on record. Who has issued the caste certificate to you? The authority from where you belong, or the authority where you have got married?
The authority from where I belong.
Where is that?
That has not been annexed in the petition minutes.
Yes, sir, I guess you have got the point. You may want to bring the caste certificate on record. These circulars of Union of India are solely for the purposes of giving the place from where the caste certificate is to be issued.
But the reference of the Union of India notification I have just brought it.
Yes. Because the necessary inquiry has to be done there.
It is there.
These notifications we have considered in the case of Mittu Pasi.
This is the notification. This is the notification referred in the circular which is annexed.
These are verification of caste certificates.
It is there.
The community which the petitioner belongs is the Bahu.
It's the daughter-in-law of this.
Both of them are the
belonging to
Another state.
Another state. Where is your caste certificate?
It is also not on.
Your caste certificate is also not.
But Your Worship, I was appointed on the basis of because I belong to my parents' state also.
Where is your caste?
I will not annex the caste certificate. However, in her caste certificate will be evident from page 32. DC has said in the DC order.
Who has issued the caste certificate? Yes, sir. Like us, you please explain. You have got the point. What do you say so far as the status of?
Only one request. I just wanted to draw the analogy as to how the relevant point of coming for reservation will come into play or not.
Yes.
Because the reservation will come later. What are the eligibility criteria for making an application has to be seen through the rule itself. So therefore, I just wanted to indicate and place the rule first, and then I'll just show the judgment of Honorable Supreme Court as well as of the other High Courts. But leadership, I have the rule for a while. Rule 3.
This is dated 39. Which rule?
Leadership, I can give a copy.
26, 2006.
No.
Give me the rule.
This is the rule. Presently rule.
Yes. Rule 3.
So 2022 is the rule. Rule 3 says आंगनवाड़ी सेविका सहायिका के चयन के लिए नामांकित अहर्ताएं शर्तें होंगी। आंगनवाड़ी सेविका के लिए न्यूनतम शैक्षणिक योग्यता इंटरमीडिएट 12वीं कक्षा उत्तीर्ण होंगी एवं आंगनवाड़ी सहायिका के लिए न्यूनतम शैक्षणिक योग्यता मैट्रिक 10वीं कक्षा उत्तीर्ण होंगी। आवेदन के समय आंगनवाड़ी सेविका सहायिका के पद के लिए नियुक्ति हेतु इच्छुक आवेदिका की उम्र 18 से 35 वर्ष के बीच होगी। आवेदिका पोषक क्षेत्र के गांव की बहू होनी चाहिए। अविवाहित लड़कियों का चयन इस पद के लिए नहीं किया जाएगा। अपवाद में वैसे अविवाहित लड़कियां चयनित हो सकती हैं जो दिव्यांग हो परंतु कार्य करने में सक्षम हो। समान योग्यता रहने पर चयन में विधवा, परित्यक्ता, तलाकशुदा को प्राथमिकता दी जाएगी। विधवा, परित्यक्ता, तलाकशुदा महिला को इस आधार पर चयन के लिए अयोग्य नहीं किया जाएगा कि वे गांव की बहू नहीं है। आंगनवाड़ी सेविका सहायिका प्रश्नगत केंद्र के लाभांतों के उस वर्ग से होनी चाहिए जिसका उस आंगनवाड़ी केंद्र के लाभांतों में बाहुल्य हो। आंगनवाड़ी केंद्र के लाभांतों के बाहुल्य वाले वर्ग में निर्धारित शैक्षणिक योग्यता के उम्मीदवार का अनुपलब्धता की स्थिति में सेविका सहायिका का चयन उसी पोषक क्षेत्र में निम्न अग्रता से की जाएगी. Now comes the reservation point of whether ST and SC so and so. So the point is making the rule itself बाहुल्य वर्ग के होने चाहिए. The majority of population on one particular area should be from that particular area. The applicant should be for the purpose
Irrespective of the fact whether the candidate belongs to
any place. Now the legislative intent is clear from the rule itself. The bahu उस village की होनी चाहिए. There is no boundary. The Jharkhand की bahu होनी चाहिए. And coupled with the fact that ladyship, I just wanted to indicate, I have just got few judgment also. It is a settled principle of law that as per the judgment of Honorable Supreme Court and the notification of the central government, nobody can claim reservation if they migrate to other place. Now, another question was evolved in 2013 wherein Honorable Justice D.S. Singh has referred to a larger bench which has been settled in 2018, wherein the concept of marriage, it is not a purpose chooses to migrate somewhere. A lady do not pick and choose if the marriage takes place and the lady goes to a particular village, she is being a bahu as per the rules. Now, nobody can say that she can go back to a place and she can again get a job. So the legislative intent is quite clear. The rules itself says bahu village ki honi chahiye. There is no boundary specific. Now, coupled with the fact to go for a harmonious construction on this aspect, the scheme of integrated child development scheme through which the Anganwadi workers have been appointed, that is a central government scheme. In this rule itself, the component of this honorarium payment is there, not salary but the honorarium. 60% earlier the state central government was bearing and 40% the state. Now it is switched over to 80 to 20% ratio of the state being bearing 80%, now 20% central government. Still the scheme is being implemented of the central government itself. State is just an instrumentality to develop and project those schemes. Now the point is in this matter what my learned friend has referred to a judgment and I am glad to always read Justice S.B. Sinha's judgment most of the time. There is a judgment of state of Karnataka, Amir B. Is there. I just quoted from the SSC online citation itself.
One malus that has been provided malus.
So relevant would be I just read to abstract of para 13 and 20 in this matter, page 7 and 8. Page 7 and 8. 7 says, para 13, the post of Anganwadi workers are not statutory posts. They have been created in terms of the scheme. It is one thing to say that there exists a relationship of employer and employee by and between the state and Anganwadi workers, but it is another thing to say that they are holders of the civil post. Now, para 20 specified, very next page, page 8, Anganwadi workers, however, do not carry any function of the state. They do not hold post under statute. Their posts are not created. Recruitment rules ordinarily applicable to the employees of the state are not applicable in their case. The state is not required to comply with the constitutional scheme of equality as adumbrated under Article 14 and 16 of the Indian Constitution. No process of selection for the purpose of their appointment with the constitutional scheme exists. We do not think that the said decision has any application in this one. Now, only my humble submission would be that since the Article 16(4) do not mandates, or rather it is not an enabling provision for a state to say that the citizen of their people whosoever living inside that particular boundary of that particular state will be granted the relaxation and concession from the state being a reservation. Now in this matter, the state government has formulated a rule which says Bahu village ki honi chahiye. She is a Bahu. Now another fact I have come across in time and again in this Honorable High Court has already decided on a matter which went up to the Honorable Supreme Court in Pankaj Kumar versus State of Jharkhand, wherein categorically it was pointed out that once a person who was earlier a scheduled caste, now bifurcated state has been there, Bihar Reorganization Act is there, still that person caste is still referred as a scheduled caste in the list of state government also. So the Supreme Court has said though, no, it will be a person whosoever is a domicile of one particular by birth, that person will claim from their origin state itself. So therefore a negation was there in that terms. Nonetheless, there is another situation in other service laws that whosoever got the job before the bifurcation, they will continue to fetch the benefit of reservation. So in this matter, since it is not a civil post, since it is the intention of the legislative intent cleared only with respect to a daughter-in-law, and more so owing to the harmonious construction with respect to the statute rules and the intention of the legislature to implement such kind of schemes of the central government, what is the role of Anganwadi Sevika? That has to be seen. Why a female has been given the charge of the
That too a Bahu.
yes
Daughter has been almost excluded.
excluded. So this is a grey area wherein Honorable Gujarat High Court has tested once. Even Rajasthan High Court has demolished a certain provision where why there is a difference between unmarried and married. So I'm not going to that because the latest position as per the rules has to be read as it is, which says Bahu village ki honi chahiye. No demarcation has ever been carved out. Now coming back to
So otherwise, which of the petitioner or the private respondent are most suitable, irrespective of caste?
the respondent number 6 owing to the marks.
Owing to the
Marks.
most suitable.
Yes, because the now coming back to the rule itself, if leadership may have the rule 11 rather. My apologies, I will just replace rule 6 first. 3.6. Three six says आंगनवाड़ी केंद्रों के लाभार्थियों के बाहुल्य वर्ग में निर्धारित शैक्षणिक योग्यता के उम्मीदवारों की अनुपलब्धता की स्थिति में.
In absence.
So therefore, thing is, whosoever is not having the educational qualification, then this process, which says अनुपलब्धता की स्थिति में सेविका सहायिका का चयन उसी पोषक क्षेत्र में निम्न अग्रता से किया जाएगा. पहला, अनुसूचित जनजाति, अनुसूचित जाति, अत्यंत पिछड़ा वर्ग, सामान्य वर्ग. And then leadership may have 11. After 10, there is a chart how to the rule 10 incorporates the शैक्षणिक योग्यता कैसे उसके points अंकित होंगे. Rule 10. So this is the basic criteria because the lady whosoever is becoming a Anganwadi Sevika and Sahika, they have to interact with the local people for the nutrition and the upbringing of the child and the pregnant woman and lactating woman.
So, a lady belonging to the majority community in the village is entitled to be appointed as Anganwadi Sevika, irrespective of the fact whether that community is a SC or ST or DC.
It's the word used as bahul वर्ग के होंगे, बाहुल्य वर्ग के होंगे, majority that particular area.
There could be a majority of forward class also in a village. Can be possible.
Yes.
Right? And the second part is that the minimum qualification is to be calculated in terms of educational qualification. Now, these two candidates, they have got the minimum qualification as per this. There's no dispute.
No.
Both the candidates, they belong to the same community.
They have claimed scheduled caste. What is the subcategory we don't know because it is not on record. So both are scheduled caste.
So scheduled caste by itself is a huge community. There could be, one Kurmi class. Well, I do not know the various classes. Some around village, or maybe we do not know. So that is not coming in their way. Has the petitioner or the private respondent, their candidature has been considered under a reserved category candidate, or they have been considered as a candidate, and it is just a chance that they belong to a reserved?
No, because these applicants are being an applicant, they have to apply on that particular area when bahulya work ke honge.
That's right.
So therefore, a scheduled caste area is there. Therefore, the scheduled caste applicant is there.
Therefore, right? So therefore, the entire area is belonging to a scheduled caste, and scheduled caste applicants are there. And the case of the petitioner is that the private respondent has got is a bahu of belonging to a prior to
Erstwhile
Bihar.
Bihar.
And she produced the certificate of state of Bihar, which was observed by the DC also. So, if your lordship will see page 32, the DC says that the certificate which was produced was from state of Bihar in Aurangabad. However, if your lordship will see article 341 and 342, your lordship is very aware.
So, do you want to say that in a case of scheduled tribe or scheduled caste village, the bahu who has come from another state will be debarred?
No, her caste certificate has to be then up from the same state, and thereafter she can contest. She can contest.
It can't be.
Yes, it can be.
Husband's name, the certificate cannot be obtained by any caste.
She cannot have a caste certificate from another state. There is no such provision.
Lordship, if Article
Her
340.
caste status will always be issued from the place she originally belongs.
Then, Your Lordship, therefore, that's the circular which says that that's why her caste certificate is from the state of Bihar. Therefore, it's debarred. And Article 341 also, Your Lordship, persons of scheduled caste in state of Bihar may not be scheduled caste in state of Jharkhand. Also, so it has to also look.
No, there is no dispute on that. The caste is common in Bihar and Jharkhand.
No, Your Lordship, there are few castes.
No, not few. I am talking about your candidate.
My candidate is not her candidate.
Both of you
Mine is of state of Jharkhand.
What is your caste?
Tobi.
What is your caste?
Not same.
Tobi is not scheduled caste or scheduled tribe.
Scheduled caste.
BC.
Yeah, Tobi, Your Lordship, as per my knowledge is scheduled. But however, Your Lordship, if search to Article 341, for a moment I'll just, what my learned friend.
What is your caste?
I just speaking.
Petitioner is Gopi, right? And belongs to which place?
State of Jharkhand, Palam.
Palam. You are a Bahu over there?
Yes, I am a Bahu.
You originally belong to which
State of
place?
Jharkhand.
Which place?
Jharkhand, Your Lordship, which place that?
There is your educational qualification that will reflect.
That we have not annexed, Your Lordship.
You have annexed it, no?
No, the education qualifications I have not annexed.
Where is your caste?
Caste certificate is. Your Lordship, till then Article 341 will make clear of what my argument is. Article 341 of the Constitution. May I please, sir?
Yes, if you just say what you want to say by referring to Article.
Yes, the President may, with respect to any state or union territory, or where it is a state, after consultation with the governor thereof, by public notice, specify the caste, races, or tribes, or part or group in relation to that state. The line is.
Is there any fresh presidential notification issued with regard to this caste after 2000?
No.
No. The presidential notification in connection with these castes have been issued prior to 2000. So that particular presidential notification was fully applicable in undivided state of Bihar. Merely because there is a bifurcation of state of Bihar and state of Jharkhand, does that particular caste certificate is useless for the state of Jharkhand? Or it only says that does the caste status is taken away by the candidate? No.
Every year it's renewed, Your Lordship. Every year the caste certificate.
Caste is given by birth in our
Certificate, caste certificate, Your Lordship. Caste certificate.
Caste is a matter of status by birth.
Yeah, caste is.
It is. So your submission is that it is not public employment, therefore Article 16 will not apply.
Which enables the state government to extend reservation for the citizens also. I am driving the analogy from the fact itself. Village Bahu village ki honi chahiye. There is no boundary as such carved out in the rule itself. And coupled with the fact, since it is not a civil post, claiming the circular from Annexure 5, that is only with respect to the civil post where the reservation has to be given, and there is a earmark post. The cadre strength has been decided, but then here it is not the case. The Anganwadi centers have been decided by under the presidency of the presidency of the DC concern, being in the committee, and it has been started in the year 1975. So since 1975, the Anganwadi Kendras has been established in Jharkhand also and Pan India. And thereafter, the 2006 was
the question of reservation in the sequence of order will come only when there is Bahu not available from the majority.
Who are not having the education qualification, then
yes.
And just to give the reference of Bahulya work ki hone chahiye, the reference is coming only with respect to the majority people whosoever is residing there, same caste has to be given the privilege for the becoming an applicant for the purpose of consideration thereof.
Caste certificate is invariably issued in the name of so and so, son of so and so, or daughter of so and so. Like PAN card. PAN card is also issued in the same manner. The identity is always the parentage. In caste certificate also, identity is always the parentage. Because it has to be issued from the place you actually belong to, irrespective of your marital status. You will bring your caste certificate or you don't?
Okay, she's also told me.
I want to see your caste
I'll
certificate.
bring on record. I'll bring on record.
You will bring on record the caste certificate?
I'll also.
You file your caste certificate, both of you. You file it by Monday.
So a little more time will be going to go.
The counsel for the parties are present. Petitioner and respondent number 6 are fighting with respect to the caste status, but the caste certificate issued to them is not on record. Counsel for the parties are directed to bring on record the caste certificate, which was subject matter of consideration before the respondents. Let the respective supplementary affidavit be filed on Monday. We post it for further hearing. Bring your caste certificate.
Lakshmi, do we get till Tuesday this after? Tuesday after.
You can bring it.
Yes.
File it during the court proceedings. I have to go through this. There is one more judgment of the Honorable Supreme Court, as I recollect, that so far as the status of SC is concerned. You play SC, no?
SC.
SC is concerned, it is planning.
Veer Singh.
That Constitution Bench judgment is there, 2018 Veer Singh, when the Honorable Mr. Gogoi has written the judgment. So that judgment has clarified the person cannot claim from the other state to other state. If they are migrated, the certificate can very well be issued by the state government, looking into the certificate of the Bihar in this case. But then claiming the job on the basis of reservation with respect to the state posts, so that is not the case. So leadership may recall the rules again. The component of the honorarium is also coming from the central government. Let's in the situation of central government jobs, one cannot discard that you coming from Bihar, you cannot do a job in.
Your short synopsis. Please do it. Whatever you have submitted, please do it.
The judgment your lordship is referring to. The judgment.
I have also annexed the Veer Singh judgment in my compilation.
You have referred to this, you have annexed it.
Veer Singh is the serial number 2, Veer Singh is there, Constitution.
We'll see it. We'll get it.
Pleasure.
Please do not make submissions which are not borne out. Please do not make submissions which are not borne out. If you have made an allegation in your petition, you are free. But if there is no such allegation in the petition, please do not. Merely on the basis of it. There can be a gap. Right? I issue you an appointment letter, but you don't get it. An appointment letter is issued to you or respondent number 6, but you are not aware or they are not aware. And the difference in the period is very less. So there is a possibility that it was not duly communicated. So that benefit you have to give unless you allege. No such supplementary is required. We just need the caste certificate. We will decide the issue.
Item 14, WPS 3227 of the 2023.
काउंटर फाइल करने के लिए सर बोला गया ना.
There was he had forwarded a letter, Lordship, and we have received certain instructions, but it needs further clarifications.
Time till 13 March is granted to the how many? 13 March?
4 weeks, ma'am, because there is
Almost 4 weeks. 20th March, granted to the respondents to file the contract with it in terms of order dated 14/20.
20th March court is
20th March, the court is open. Post on 3rd of April.
open.
20.
Oh, I heard 20.
Item 15, WPS 3650 of 2023.
My lordship, I superannuated on date. Unfortunate, this is the unfortunate part. I am
You
appointed
go to
by the.
mediation.
My
Your,
lordship,
all your grievances will be taken care of.
it's an unfortunate part, my lordship. I am appointed by the Bihar Public Service Commission for each and every redressal of my grievances. I am appearing
Meetings
before
are
this
complete.
court. My lordship, yes, my lordship.
Meetings are complete.
No, my lordship,
Counter
IA petition has been filed under section 340 of the CRPC because of the respondent
Who
are
has
not
filed IA petition?
myself.
That is not
For
on
the-
board.
Yes, my lordship, on date IA number 1281 of 2014 to 2024. Filed on 6/2, 1281.
It's the same thing. This IA.
There are two IAs pending. One IA has been pending for amendment in the prayer portion because of my gratuity has been withheld. Due to one impugn notification issued by the finance department, and gratuity cannot be withheld because of I have earned it into the entire service period. This honorable court has passed several orders and the respondent are not ready to comply. It's an unfortunate part. My lordship, I am coming regularly, being harassed continuously and tortured by the respondents due to raising the.
You just tell us how many cases have you filed? Give me a list of cases. We will club all the cases and give it.
This is the only for the pension matter, my lordship.
And
Because of
the
my
body
entire.
also you had one case.
That is for the suspension period. My salary has not been given. After this honorable court has passed the judgment in my favor, the respondent has not.
Read. What do you want in this IA?
I am, my lordship, see the page
IA
number.
number 10856. What is it for? Tell us. It is more voluminous than the writ petition.
Yes, because of several judgment has been annexed by the.
You just tell us what do you want through this IA? What is your prayer in this interlocutory
Quash the impugn order issued by the finance department by which my gratuity amount has been withheld. Due to the departmental proceeding.
Where is the additional relief that you are seeking? Where is the relief? Where is your petition for amendment? Your prayer for amendment? Para number?
I am just giving. Para number 2, page number 5 of the IA petition.
No, what? You want to insert some prayer?
Yes, my
So
lordship.
you should know how to file an amendment petition. This is not the way to file an amendment petition. This is not the method of filing an amendment petition. You have to tell us that after this, which paragraph, this paragraph is to be inserted, this prayer is to be
Yes,
inserted.
that has been mentioned, my
Where
lordship.
is it mentioned? Where is it mentioned?
Yeah. Just, I am giving, my lordship. I am very sorry. I am giving. That 41 serial number 41, page number 51. That the paragraph number 2 and 3 of the prayer portion may be allowed to be added as the main writ application forming part thereof. 51 of 55. If there is some inconvenience, my lordship, I am apologizing because of I am not professional, but the respondents are not ready to comply the order passed by this honorable.
Page number 51.
Page number 51.
That paragraph 2 and 3 of the prayer portion will be allowed to be added.
Yes, my
Is
lordship.
this the amendment you are seeking? If you are not able to file a proper petition, you take assistance of an advocate. This is not the manner in which an amendment petition is to be filed. Right? And your main relief, what is the main relief in your case?
Presently, my lordship, please see the
Your main relief, I just want to see. What is the main petition about?
to release the pension.
You are seeking payment of the gratuity also.
Yes, my lordship.
Right? And by which order the gratuity has been written? What is the date of the order by which your gratuity has been written?
Yes, my lordship, just one minute. (43C) of the, they have not issued, but IA 02 and 03, page number 60, 59 and 60. 43 ख के अंतर्गत संपरिवर्तित किया जाता है because of departmental proceeding is continuing. IA 02 page number 59 and page number 60.
So, 5/10/20. That order has been passed.
Yes,
right?
ma'am. Yes, ma'am.
So, you want to challenge this order?
Yes, my lordship.
You file a separate petition.
But the pension must be given, my lordship. Meanwhile, pensions should not be. Gratuity, yes, that has been decided by another. I may file. If the honorable court will permit, I will file the amendment
You are a
petition.
dismissed person.
No, my lordship.
सेवा के फलस्वरूप उनके विरुद्ध it is just a conversion under section 43.
Yes, my lordship. Because of from 2010, the departmental proceeding is continuing, and till after superannuation, the departmental
What is the
proceeding.
present stage of the departmental proceeding?
12-13 साल हो गया, my
What is the
lordship.
present stage of the department?
Nothing, I do not know. I am not aware because of they are not.
participating.
Yes, they are not sending any letter to me that the departmental proceeding is continuing or whether the inquiry date has been fixed or such and such date I have to present. So how I could know? There are 8 departmental proceedings continuing and nothing, no allegation I could
When
get.
were you put under suspension? Were you ever put under suspension?
Yes, my lordship.
When?
Page number, annection number 20.
Give me the date, please.
Just a minute, please. My lordship, I am giving.
Respondent. There is a pendency of departmental proceeding against him. There is no order of punishment.
More than that, I'd like to place some of the paragraphs of our affidavit dated 11th of December 2023.
Please appreciate. These are so many petitions. This petition has not also been properly filed. There is a pendency of departmental proceeding against him. Can you withhold this pension?
No.
You release it?
हम बता रहे हैं, इसलिए हम बोल रहे हैं कि एफिडेविट देखना जरूरी है. Kindly see affidavit dated 11th of December 2023.
Your affidavit?
Yes, our affidavit. Counter affidavit by 1 to 4, respondent number 1 to 4, dated 11th of December 2023.
Which paragraph?
Paragraph 13 onwards, I'll place. Paragraph 13, I'm placing.
You just tell us the gist and then we will.
I'll place it.
No, you just tell me the gist. What do you want to say? Because just now you
There
said
are many things. Normally, I say in gist. Normally, I do not praise all the paragraph. But in this case, I'll say it is necessary. Therefore, I'm praising it. And permit me to praise. Paragraph 13. ये तो पेंशन में बहुत बोलने का रहता नहीं, 2 लाइन का बोलते हैं, बट यहाँ जरूरी है. Paragraph 13. Page 12. That is most humbly stated and submitted the petitioner is the habitual litigant as he has filed as many as 54 petitions SLPs in this High Court as well as Honorable Supreme Court. Most of the writ petitions have already been disposed of by the Honorable Court for being false and frivolous in nature. Paragraph 14. That is most humbly stated and submitted the petitioner is not a crusader of corruption as he portrays himself to be. In fact, he has a checkered history of indisciplined behavior, alleged charge of corruption against him and various other omissions and commissions. And therefore, it is appears necessary to narrate various aspects of this past conduct for better appreciation of the facts. Paragraph 15. That is most humbly stated and submitted that as many as 12 departmental proceedings have been instituted by the state government, out of which he has been punished in 4 departmental proceedings after due process of inquiry and conclusion of departmental proceeding for proving charge of irregularities, defalcation, embezzlement of government fund and indiscipline. Then paragraph 17. That is stated and submitted the petitioner has been put on suspension and departmental proceedings withdrawn on various occasions in the state of Bihar and Jharkhand throughout his tented career under the grave charge of misconduct and defalcation of huge sums of government money meant for development works, conservation of forest, and providing wages and other benefits to local poor villagers. Paragraph 18. That is humbly stated and submitted that the petitioner has been inflicted with the following punishment after due process of inquiry and conclusion of departmental proceedings for proving charges of irregularities, defalcation, embezzlement of government fund, and indiscipline as contained in the government notification enlisted in tabular form. That we have given the tabular form of those. Paragraph 19. That is stated and submitted that 8 more departmental proceedings have also been initiated against.
I read it. I'm a very fast reader. Page number 23. Please.
Page number 23 from the top. नहीं हम top पे पढ़ेंगे.
He is convicted. He has deposited amount. He has done everything. But in spite of all this,
pension. अब आ रहे हैं उस
there is no order of dismissal. He was made.
हम उसका जवाब दे रहे हैं.
Retire.
Now what happened is हम आपके जवाब दे रहे हैं.
There is a pending departmental proceeding which you have converted under 43. Now you tell us that even if a person has faced many departmental proceedings, he is not of a good character, he is corrupt, he is whatever, 54 cases, 105 cases, whatever. But you allowed him to retire on 31/3/2023. Can you, under which provision of law, you can withhold his pension?
अब reply करें. He retired in March 2023. We processed for payment of his pension. We sent the file to the Accountant General. Accountant General noticed that there has been unauthorized absence for many periods. Those have not been regularized. And the total number of days are 1,000. Once a person is found to be unauthorized absence, how we are helping that advantage? If a person is found to be unauthorized absence for more than 6 years, then it is treated to be break in service, no pension. We don't want, he should not get pension. Then we requested him, जो आगे के पैराग्राफ में है जो अभी हम पढ़ नहीं पाए, we requested him in November that you please make an application for regularization of those absent periods. He was in Bihar. Some of the periods are of Bihar. He came to Jharkhand on bifurcation of the state and on being allocated the state of Jharkhand.
In absence of any order to this effect, how do we buy that?
Let me complete. In November, we requested him that you make an application for regularization of those absent periods. He made an application, that also lot of errors. We wrote him a letter, please rectify these things. He rectified in December. Now we are trying that this absent period after regularization should not exceed 6 years, should not exceed 600 years, so that he gets a pension. अगर इनका हम 1000 का कर देना तो ब्रेक इन सर्विस हो जाएगा, पेंशन भी नहीं मिलेगी.
कौन सा सर्विस रूल है जिसमें लिखा है कि 1000 दिन absent
हाँ वो आपको हम दिखाते हैं. But right now, this is the statement we have made. Now,
you see, there has to be a rule to this effect.
yes, of course.
It
Nothing.
is one thing to say that he has abandoned the service, you would not have permitted him to join. That is a separate thing.
वो भी हम प्रोसीडिंग करके ही भी करेंगे, वो भी हम प्रोसीडिंग करके ही करेंगे. Now, अब क्या है? Now on his application, we are in a process of regularizing those absent period, and only thereafter we will again send the file to the accountant general and allocate his pension. This is the latest, I think within 15 days. I think within very short time regularize हो जाएगा, he'll get the pension. Those things are not there, but इसमें देखना था, जो और भी दिखाना चाह रहे थे वो देखना जरूरी था. This what we are doing. People are helping him and he is making allegation. Not only that he has made allegation against the officer, he has made allegation against a sitting judge of this honorable court. In writing.
Please don't try to prejudice.
ये है लिखा हुआ, ये this on record. This on record.
I have to say,
this on record. Prejudice करने का बात नहीं. I am not making a story.
See the judgment passed by this honorable court on date 20/12/2023. Mrs. Chaitali Chatterjee.
आप हमको सिर्फ इतना बता दीजिए कि इनका entitlement of pension का denial का कोई provision
हम डिनाई नहीं कर रहे, हम डिनाई कहाँ कर रहे?
But they are delaying.
हम डिनाई कहाँ?
Unnecessary delaying 1 year. And
दूध के धुले हुए नहीं है.
My lordship, I am saying
डिनाई कर सकते थे.
Decision लेने में so far as pension is concerned and he survives at least.
Once it is regularized, that is in the process. उसके बाद भेज देंगे accountant general को and he'll get the pension.
How much time? Some timeline has to be there.
I think 1 month maximum. On the outer side, I'm saying.
If it comes, you will do the needful.
Yes, within
It
2
was
to 3
sent
weeks.
to your lordship.
They had already sent.
They have sent to the AG.
Yes.
The learned counsel for the parties are present.
थोड़ा इसको कम किया जाए, my lordship. मेरी family entire. My daughter is studying at LLM Gujarat National Law University, and I am not in a position to pay some rupees because of their food items.
SIS we have paid, GPF we have paid within 15 days.
You see, this kind of, please don't.
My lordship.
Don't argue in this manner. It can't be like this. And you are filing petitions after petitions. I don't know how many petitions.
Now we are being charged with the perjury 340 applications.
Before the honorable this court, they have said that I am giving the same time. This is going on a repeated times. They are appearing before the court. They are saying that I am giving the pension and they are denying, and I am running behind them.
The petitioner in person and the counsel for the respondents are present. It is not in dispute that petitioner has attained the age of superannuation on 31/3/2023. It is further not in dispute that a disciplinary proceedings was pending before the an order has been passed under Rule 43B of Jharkhand pension rules for the purposes of disciplinary proceedings against the petitioner.
Continuing from 2010.
But no final order has been passed so far. The petitioner in person has submitted that there can be no reason for not making payment of pension. The learned counsel for the respondents has submitted that the petitioner has a checkered history and petitioner has been filing numerous cases. He has been punished in departmental proceedings on a number of occasions.
That are subject before this honorable court, my lordships.
आप क्या चाहते हैं? आपका सुनना बंद कर दे, admit
I am
कर
very
दे, छोड़
sorry.
देते
I am
हैं?
very sorry. I am very sorry.
कितना बोलते हैं?
परेशान करके रखते हैं।
इसीलिए आपका केस डिसाइड नहीं हुआ। आपके फेवर में कुछ लिखाने जा रहे थे, अब हम भूल गए।
I am very sorry, my lordship. I am very sorry.
The learned counsel for the respondents has submitted that the matter regarding grant of pension to the petitioner has remained pending as certain formalities were required to be completed by the petitioner himself. He has submitted that the matter regarding payment of pension is in advanced stage, and once the formalities are completed, needful will be done by the respondents. The council submits that a supplementary affidavit to this effect will be filed within a period of 1 month. 1 month?
ये हम लोग एक एफिडेविट नहीं फाइल कर सकते, हम लोग लिखेंगे वेरी शॉर्टली, वो जो रिक्वायरमेंट है मेरे ख्याल इसमें है.
Within a
If you
period
permit,
of 1 month from today.
if you permit, we'll file it.
Also, for the state is directed to seek instructions and file the required affidavit with regard to the status of payment of pension to the petitioner. That should be sufficient. एक महीना बाद the affidavit be filed by 21st March. Post on 1st April.
But the respondent state has to file.
Respondent state has to you also file.
If we receive anything,
If you receive.
yes.
If the appropriate communication is received by the accounting general office, the status with regard to the petitioner be filed through an affidavit.
अमेंडमेंट पेयर प्रेयर के लिए आइए वाले.
पहले आप पेंशन ले लीजिए.
Yes, my lordship.
उसके बाद सब. Then we will see. Then you will withdraw 340.
Yes, my lordship. Of course.
You remember these are all recorded proceedings.
Yes, my lordship. But
If you
it
get
is
pension, you will
needful.
withdraw
My entire family is hand to mouth. See how they are treating. One departmental proceeding in
बाकी
general.
सब cases में जिसमें काउंटर नहीं आया है उसमें काउंटर फाइल कर देते हैं. I just mention those matters. The counter has not been filed.
आइए का
नहीं बहुत सारे केस में काउंटर नहीं फाइल हुआ है. These are on board.
Serial 18.
Serial 18. 18.
Counter आई.
Serial number 15.
I can do one thing. I can check up the record, and in those cases where counter has not been filed, I will give further 2 weeks time or 3 weeks time to file a counter. I'll check up the records.
We give the parents.
You can need not be. You can give the clearance, not the clearance, but at least that formality should be complete, and you ensure filing of the counter.